All right. Hey, what's up? This is Mr. Ippolito. Today we're going to go over the 2024 Bill of Rights Scenarios quiz. This was a real Bill of Rights Scenarios quiz that I gave back in 2024. And it's great practice because this is the exact format that your real quiz is going to be. The directions are going to be the same as well. So the first thing you're going to do is circle if government is violating or government is not violating. You're then going to write down the amendment that is involved. And then finally, you're going to explain your answer using enough detail to show that you understand why the Constitution is being violated or not. So you're going to need to know either those phrases from the Bill of Rights or the principle behind it, right? For example, if it's the Eighth Amendment and it's you shall not be subject to cruel and unusual punishment. That is the exact phrasing from the Eighth Amendment. Or you could say the punishment must fit the crime, right? That's the principle that's involved. So you need to explain, you need to let me know for each explanation that you understand the constitutional principle at work here. So let's go ahead and look at scenario number one. A public school, remember that public schools are funded by the government, allowed student-led prayers during the morning announcements to pray for the team every Friday before high school football games. Some students objected, arguing this was a government endorsement of religion. This was an actual real Supreme Court case. Was the government violating the Constitution? The answer is yes, it was. It's the First Amendment. You have to remember that at a public school, school resources may not be used to promote any one particular religion. It's called the Establishment Clause. If you look at the First Amendment, Congress shall respect no establishment of religion. We began this country as a country where we're not going to use taxpayer dollars, taxpayer resources, that includes public school resources, to promote any one particular religion. Now, the FCA, the Fellowship of Christian Athletes, or the Muslim Student Association, for example, they can meet. It is student-led and student-initiated. You may be like, well, Mr. Ippolito, student-led prayers, you just said student-led is okay. But the fact that they're using the announcements to basically, like the morning announcements, everybody has to watch. So everybody is subject to the morning announcements. You can't use that to lead people in prayer, whether it's teacher-led or student-led. FCA, Fellowship of Christian Athletes, if you don't want to participate in the prayer, don't go to the meeting. Muslim Student Association, if you don't want to participate in the religious conversation there, don't go to the meeting. You have a choice there. The morning announcements, everyone is subjected to. That's why this is a First Amendment violation. Scenario number two, we talked about Madison being charged by police with assaulting 15-year-old Emma. She says that she was at Starbucks. She wasn't at the location at the time. And the answer to this one is the government is violating the Constitution. It's the Sixth Amendment. In the Sixth Amendment, you have the right to secure witnesses in your favor. In other words, if there are witnesses who can attest to the fact that you were not there at the scene of whatever crime you're being accused of committing, then you have the right to secure witnesses that say that person wasn't there. It's also called an alibi, right? If you have an alibi, that means you have someone who can corroborate the fact that you were not in the place where you're being accused of being and committing this crime. If the Starbucks baristas could not testify, you could also subpoena. That is a legal term that means to legally force someone or something to be presented in court. You could subpoena the tapes, the security tapes in Starbucks as well. So that is Madison's Sixth Amendment right. And again, for the purposes of the test, as I mentioned, or the quiz, if it is the Fifth or Sixth Amendment and you're not quite sure, you can write 5/6, and I will accept that. Okay. Number three, the Valencia Town Center. We talked about this in class. It is private property. So if the security guards escort you off, then they are not violating the Constitution because they're not the government. Again, the young people here, they might say, well, it's my right to peaceably assemble under the First Amendment. How dare you infringe upon my right to peaceably assemble? You have the right to peaceably assemble on public property. The Valencia Town Center is privately owned by Westfield or whoever the owner is these days. It is private property. Mall security can be sassy if they wish. They're not violating the teen's right to peaceably assemble. If they put hands on you, then we've got another story, but they have been trained. Mall cops have been trained not to touch you, right? That is beyond their purview. If you refuse to leave, then the sheriff's department can come and physically escort you, take you by the arm, and physically escort you off the property because otherwise you can be charged with trespassing at that point. All right, number four, this is the F Trump shirt, and it's the actual F word. And of course, if an administrator like Ms. August, who was our assistant principal during that school year, if you get dress coded by an administrator, government is not violating the Constitution. You might claim it is your First Amendment right to free speech, but the fact is that even though you think you're engaged in political speech, which you are, that's not the reason why you're getting dress coded. You're not getting dress coded for the political speech. You're getting dress coded for the profanity, for the F word. So the government is not violating your constitutional rights if they limit your ability to wear the F word on your shirt. Public high school principal smells marijuana smoke down the hallway. This is, and then she decides, you know what? I don't know where it's coming from. We're just going to search every kid's backpack who's ever been busted for drugs or alcohol. The government is violating the Constitution. It's Fourth Amendment search and seizure. This is what's called a sweep search. This search is just too broad to conduct without a search warrant. There's no probable cause. There's no search warrant. So that principle is violating those students' constitutional rights. Number 6, the town needs more land to build an elementary school. We've talked about this before. This is the last phrase of the Fifth Amendment, where government may take land, excuse me, for public good with just compensation, with fair compensation, which means they got to pay you the fair market value for your land, but you can be forced off of your home, and the government would not be violating the Constitution as long as they're giving fair market value. End of the Fifth Amendment. It's called eminent domain. Number 7, 23-year-old Connor is speeding, making unsafe lane changes. So when he's staggering and slurring his speech, the fact that he's speeding by itself is not probable cause. Making unsafe lane changes, also not necessarily probable cause by itself, but once you get out of your car and you stagger and slur your speech, and if the deputy can smell alcohol on your breath, now the deputy has probable cause. Connor is likely DUI, driving under the influence. So if the cop searches your car, and if you are Connor, the government is not violating your constitutional rights. The Fourth Amendment is involved, but the deputy has probable cause. It is a reasonable search in the eyes of the law. Number 8, the government tries jury for murder, but the jury finds him innocent of the crime. But then you find new evidence, and you're like, hey, let's put this guy on trial again. You can't do that. In this case, the government is violating the Constitution. It's a principle called double jeopardy. You shall not be tried for the same crime twice, which puts the burden on the government. If they're going to charge you with a crime, they need to get it right the first time. They need to gather sufficient evidence the first time, gather witnesses, gather testimony, gather statements, gather evidence, so that they can put you on trial the first time. If you are tried and found not guilty, you cannot be retried for that same crime twice, even if new evidence surfaces. Scenario number 9, cheerleader at public high school. This really happened. This was just in 2021, the Levy versus Mahanoy area school district. The key here is, the school punished her for posting nasty things about the cheer program in the school on Snapchat. In this case, the principal and the school district was violating her constitutional rights because students enjoy free speech rights when you're off campus ranting. Schools have far less control over speech off campus. If you're doing the speech on campus or at an on-campus event, at a football game, at a basketball game, at a cheer competition, that's a different story. If you're using a Chromebook, if you're using school-issued technology, that's a different story. But it was on her phone. It was after school hours. It was not at a school event. And so the school cannot punish her. Even if you sign a contract saying, I will be nice to my fellow cheerleaders, I will not say anything nasty, you can't. The Supreme Court would most likely say you cannot sign away your First Amendment rights. You can't force someone to sign a contract giving up their First Amendment rights in this instance. You can, I will tell you this, for the purposes of employment, you can limit employees' speech in the workplace and fire them. Like, that can be a condition of employment. But this is a public school and she's a student. It's different set of rules. Finally, scenario number 10, a public high school principal removed 2 articles from the school newspaper, one about teen pregnancy. This really happened, another about divorce. This is really from 1988. This is a super close call because the Supreme Court has gone back and forth. I don't plan to put a case that is this close. In this particular case, the Supreme Court determined that the principal was not violating the Constitution because the principal was trying to protect young readers, younger students, minors on campus. The Supreme Court agreed. But there have been other cases where the Supreme Court has supported and upheld a school newspaper or school media's right to report on the facts, like report on the truth, even if it's controversial. So this one's a close one. I'm going to try my very best not to give you any really close calls. I'm going to try to make each one of these scenarios like crystal clear, whether it's one way or the other. All right. Well, that is 10 scenarios in less than 10 minutes. Good luck on your Bill of Rights scenarios quiz. Thanks so much. Have a great day. Bye-bye.